I'm New York attorney Craig Delsack, and this is part one of my checklist for negotiating the terms for the purchase of a business. After you've found your target business to acquire, you should negotiate the terms of the transaction by creating a term sheet. This is also known as an LOI, a letter of intent, an MOU, or memorandum of understanding. The term sheet will set forth the parties' mutual understanding of the terms of the deal. Also, having a term sheet communicates to the seller that you are serious about purchasing the business. One benefit of a term sheet is that it can prevent the seller from looking for other purchasers. It also helps flesh out the major issues that often arise in a business purchase and sale. Here is a list of typical terms addressed in a term sheet. Names and contact information of all parties. This sounds basic, but you need to have all the names and contact information for all parties involved: the buyer, the seller, their respective attorneys, financial advisors or accountants, and any brokers involved in the deal. Purchase price and other consideration. Will this be an all-cash deal or a combination of cash and other property, stock, maybe intellectual property? Payment terms. If a cash deal, will it be paid in a lump sum or paid in installments? If paid in installments, what is the down payment amount, and will the payments be tied to profitability or other contingencies? If seller financed, what is the interest rate and payment period? If financed by a third party, is the deal contingent on obtaining that financing? Collateral for the purchase price. If the business is being sold with seller financing, the seller may want collateral for your promise to pay back the loan. Perhaps the collateral will be the stock of the company, some or all of the business assets, or some other real or personal property. Structure of the deal. Assuming that the business target is a corporation or an LLC, you can structure the purchase in one of two ways. Either it will be a stock purchase or an asset purchase. There are advantages to both, and both may have significant tax implications. You should structure the transaction after obtaining advice from your financial advisor. From a legal perspective, a stock sale is quite different from an asset sale. In a stock sale, you are buying all of the stock of the company and all of the company's assets, liabilities, goodwill, contracts, IP, and real property. You are buying the company lock, stock, and barrel, which means you may be buying the company's headaches as well, like lawsuits and other contractual obligations. In an asset purchase, you are cherry-picking and buying the plum assets that you need for your own business, or even a division of the seller's business. In an asset sale, the company's liabilities and other headaches stay with the seller. Whether you are buying the stock or the assets of a company, you should conduct intensive due diligence to make sure you know what you are buying. This concludes part one of the checklist. In part two, we will look at transfer issues, covenants, and more. I'm Craig Delsack, nyccounsel.com, reminding you this is just a brief guide and you should consult with a lawyer before considering buying a business.